Time now to welcome our legal expert who is joining us from our Mumbai studio, Vinay Singh, founder and owner, Vinay Singh and Associates, and a property expert. Vinay, thank you so much for joining us. We have a number of questions coming in to seek your legal advice on their property dilemmas. First is an email from Parvez Khan. Parvez wants to sell a property he has in Kamote. He says the property is jointly registered with his dad, who is no more. The society was registered after his father's demise. The society has now issued share certificates in his name upon giving indemnity and NOC from his mother and brother. Is he now okay to sell this property? Does he have all the legal documentation in place? Vinay.
Well, Vasudha, one of the things that property owners must realize is that there is a difference between being a member of the society and being a co-owner. If your name is there in the agreement or you have inherited it, then you are definitely a co-owner. But the society format presupposes that there is only one member. The others are what are called associate members. So while the shares may stand in his name, his mother and his brother both do have shares in the property. So when he goes to sell, these people also would become sellers in that sense. They do have a share in the property and that cannot be taken away. So he'll have to make them also sellers. In the alternative, if he wants to acquire full rights in the property, he must ask his mother and brother to do a release deed and release the property in his favor and go and have that release deed registered.
Okay, so in this case, the laws of succession and what defines the framework of a will, that will govern how this property is transferred.
Yes, yes. Since there are Muslims, they cannot give away more than 1/3 of their property by will. If there is no will and the entire property was belonging, say, to his father, then now the mother would have a 12.5% shares and both the brothers would have 43.75% share each. So this is how it would be, and they'll have to all become sellers in that sense.
Okay, so Parvez Khan, hope that helps you. Next, Gaurav Martha has a question. He's joining us on the phone line. Hi, Gaurav. Go ahead.
Hello. Okay, actually, I'm planning to buy a plot in Pimpli Gurava, PCMC. Details of the plot size, if you really want to know, it's about 1,500, and the year of this particular plot purchase is 97-98. My question is, when the seller bought this plot, it was under agricultural land. All right. Now the whole area comes under PCMC and the survey number is provided to the plot. The seller is selling the plot with 7/12 extract, sale deed, and has clarified that he will not be able to convert the land to NA apart from handing these documents as he's abroad. So what is the process to convert the agricultural land to residential? How much time will it take? What's the process? And how will I be able to take the loan for construction on property from a nationalized bank? Will I be able to take a loan from a nationalized bank?
Okay, of course. So buying and selling agricultural land, the process is fairly similar, but there are some do's and don'ts and there are some exceptions. Vinay, can you just run Gaurav through them?
Number one is that you cannot buy agricultural land unless you are an agriculturist. Now that you have bought it, I am not going to go into that question, but you will have to apply to the collector to get the land changed to NA. Unless it turns into non-agricultural, there is no way that you can construct or do any activity on that land. So that would be your first step. The time frame is difficult to predict. It depends on how efficiently you handle the process, but you could take anywhere between, say, about 3 to 6 months for this process to take place. Coming to your loan part, no bank would fund you on agricultural land, but yes, once your land is turned NA and you have an approved plan in place, then you would be able to obtain a loan from a nationalized bank for construction purposes.
Okay, so no loan until it is agricultural land, but you can always avail a construction loan on that land. Okay, the next question comes in from Nikhil Doshi. He says he wants to buy a new property which is near the high tension electric power line. Is there any guideline or rule to check before purchasing such properties? He's concerned about how this property is located. Where can he cross-check the documents the builder is by filing RTI? What are the different questions that he can fill in while applying for RTI-led information? Vinay, we see a number of projects like these also coming up in NCR and other markets which are dangerously close to high tension wires and power grids. Is there no rule book or any stipulations that development authorities can enforce on such builders?
Well, generally there would be some sort of minimum distance to be maintained. But even then, having said that, even if it is within the permissible limit, these high tension lines can cause problems like headaches and interference with your electronic devices and so on and so forth. So I think it is better to check, what kind of hazard this presents. And if it does appear to be that this is going to impact your health, health is wealth. So I would suggest that you avoid properties like this which are going to cause problems for you. Now, having said that, if you wish to still go ahead with this, since it's a if it's a plot, then you need to go and get the land records checked. If it's a house, then you need to again go and check whether the plans are in place. They have been approved by the planning authority like the municipal corporation or panchayat or whoever it is. You should also make sure that the title is clear. So these are important things. And finally, do make sure that you register the agreement as soon as possible. It is not a good idea to have an open-ended thing like an MOU or just an allotment letter. As soon as possible, please make sure that your agreement is registered. Coming to all these documents such as the plans or the IOD, the commencement certificate, and if the property is ready, the occupancy certificate, you need to apply to the plan sanctioning authority, like for example, the municipal corporation under RTI, to have copies of all these documents made available to you. Get them vetted by an expert so that you are sure that the plans are approved, everything is okay, your property is being developed legally, and that there are no other impediments in you buying or enjoying the property.
Okay, so visiting the sub-registrar's office, getting your builder-buy agreement registered, very critical for you to ensure what you're getting is there on ground and what you're getting is what is rightfully yours.